So Justin Trudeau has mandated the Minister of Canadian Heritage to enact new regulation to remove from the internet illegal content and hate speech within 24 hours or face substantial penalties. What can possibly go wrong? Viva Frei, Montreal litigator turned YouTuber, and where do we start with this story? First of all, I saw it on Ezra Levin's Twitter feed. Now, for those of you that are new to the channel, you may or may not know that I vehemently dislike Twitter as a platform. I vehemently dislike the environment in general, but I consider it to be something of a necessary evil if one wants to remain up to date on what's going on in the world. And I saw on Ezra Levin's Twitter feed a link to a story to the effect of Justin Trudeau had just mandated the Minister of Canadian Heritage to enact new online regulation. Alright, first parentheses here, Ezra Levant in his tweet referred to this regulation as censorship. That is editorializing the news. Whether or not you consider that regulation to constitute censorship is a matter of opinion, but there is regulation. Carrying on. The object of this regulation is that all platforms would be required to remove all illegal content, including hate speech, within 24 hours or face significant penalties. Ronald Reagan once wisely said, "Trust but verify." I have gone ahead and simplified that. I just verify. Just verify, verify, verify. So I went online to do my independent verification, and the only other article I could find on the subject came from Sputnik News. Verify, verify, verify. Ultimately, I did end up finding the actual mandate letter by Justin Trudeau to the Minister of Canadian Heritage. And it does in fact say exactly what appeared in Ezra Levant's tweet. Now, in fairness to Trudeau, this shouldn't really come as that much of a shock to people because it was part of the platform on which the Liberals ran. But in any event, let's just walk through the mandate letter, the specific section, and go over the context of hate speech in general so that you can all come to your own opinions on the subject. Dear Mr. Guilbeault, thank you for agreeing to serve Canadians as Minister of Canadian Heritage. On Election Day, Canadians chose to continue moving forward from coast to coast to coast. Parentheses here, I had to Google the third coast, which is in fact the Arctic coast, and it looks absolutely beautiful, and I must one day travel the Arctic coast. Must. Back to the letter. From coast to coast to coast, people chose to invest in their families and communities, create good middle-class jobs, and fight climate change while keeping our economy strong and growing. Canadians sent the message that they want us to work together to make progress on the issues that matter most, from making their lives more affordable and strengthening the healthcare system to protecting the environment, keeping our communities safe, and move forward on reconciliation with Indigenous peoples. People expect parliamentarians to work together to deliver these results, and that's exactly what this team will do. Now, I must admit that I am a Canadian and a lawyer, but this is the first time in my entire life where I've actually read a mandate letter from the Prime Minister to one of the ministers of one of the ministries. And I did find it peculiar because reading the document, it did read more like a political document than an actual mandate letter to a minister. So I pulled up a few other mandate letters just to see if it was something of a boilerplate document, and lo and behold, it is in fact something of a boilerplate political document. It's the exact same opening paragraph and form for all of the mandate letters. The only thing that really changes are the duties of that particular ministry. But getting back to the mandate letter for the Minister of Canadian Heritage, the relevant provisions read as follows. I will expect you to work with your colleagues and through established legislative, regulatory, and cabinet processes to deliver on your top priorities. In particular, you will create new regulations for social media platforms, starting with a requirement that all platforms remove illegal content, including hate speech, within 24 hours or face significant penalties. The first thing that people are seizing on here in order to justify their concerns is this 24-hour window. It's somewhat ambiguous from the wording of the mandate letter what this 24-hour window refers to. Some people had the concern that the minister would be required to do all of this within 24 hours of receiving the mandate letter. I tend to read it that once the appropriate regulations have been enacted, online platforms will have 24 hours to remove any illegal content once so notified, but we'll see how this pans out. And I don't think a great many people are going to object to regulations requiring platforms to remove illegal content from those platforms. I do question why any new regulations would be required, because I think we do have the required laws already in place to force the removal of illegal content from online platforms, but I may be wrong on that. I do think that what most people find even more troubling is that above and beyond illegal content, platforms are going to be required to remove stuff that is not necessarily illegal, but that is deemed to be hate speech. A ton of comments on a ton of people's Twitter feeds to the effect of what is hate speech, who defines hate speech, how does one define hate speech. Now, in Canada, we have actually had legislative criminal prohibitions on hate speech, the constitutionality of which was in fact challenged and confirmed by the Supreme Court of Canada 4-3 in a 1990 decision. And we'll get into that decision. All that to say is that we have actually had legislative prohibitions on hate speech in Canada for nearly 3 decades. Now, above and beyond how one defines hate speech, because our Supreme Court of Canada has in fact defined how one defines hate speech. People are concerned that the Government of Canada is going to enact regulations that are going to require platforms to remove hate speech before the courts have even recognized it as hate speech in the first place. In which case you're going to have a prohibition on free speech before the courts have even deemed it to be a justifiable infringement on freedom of speech. Now these are very real concerns to very serious issues which highlight the risks and pitfalls of this type of regulation to begin with. There's the expression that the road to hell is paved in good intentions, and while no one can attack the legitimacy of the intentions behind this type of regulation, one can easily see the foreseeable problems of this type of regulation. But let's just get back to the prohibitions on hate speech and how it has been defined by our court system. The landmark 1990 decision is R versus Keegstra. Keegstra was a school teacher who was accused of teaching his students anti-Semitic and anti-black course material. The students were apparently required to reproduce this material in course exams, failing which they would get penalized on their grades. Keegstra was charged with violating section 319, second paragraph of the Criminal Code. Keegstra was initially convicted, the Court of Appeal overturned the lower court's decision, and the Supreme Court of Canada by a vote of 4-3 reinstated the original conviction. And the question at law was whether or not section 319 subparagraph 2 of the Criminal Code violated Keegstra's freedom of expression as guaranteed by the Canadian Charter of Human Rights. In the event that section 319 of the Criminal Code did in fact violate Keegstra's rights to freedom of expression, was it a justifiable limitation under the law? And spoiler alert, yes, section 319 of the Criminal Code was deemed to be a violation of freedom of speech, but a justifiable limit under the law. And let's just read the provisions for clarity. Public incitement of hatred. Everyone who, by communicating statements in any public place, incites hatred against any identifiable group where such incitement is likely to lead to a breach of the peace is guilty of an indictable offense and is liable to imprisonment for a term not exceeding 2 years, or an offense punishable on summary conviction. Willful promotion of hatred. Everyone who, by communicating statements other than in private conversation, willfully promotes hatred against any identifiable group is guilty of an indictable offense and is liable to imprisonment for a term not exceeding 2 years, or an offense punishable on summary conviction. And I've gone over this in previous videos, but the difference between an indictable offense and an offense that is punishable on summary conviction, the indictable offense is more serious, carries with it stiffer penalties than the summary conviction offense. And when an offense can either be treated as an indictable offense or an offense punishable on summary conviction, it really is going to depend on the severity of the act that is the object of the offense itself. The Canadian Charter of Human Rights was enshrined in our Constitution in 1982. It guarantees that everyone in Canada will be treated equally under the law with certain benefits for citizens only, such as the right to vote and the right to enter, remain in, and leave Canada. And the two key provisions of the Act, sections 1 and section 2, read as follows. Canadian Charter of Rights and Freedoms. Whereas Canada is founded upon principles that recognize the supremacy of God and the rule of law. Guarantee of rights and freedoms. The Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Fundamental freedoms. Everyone has the following fundamental freedoms. Freedom of conscience and religion, freedom of thought, belief, opinion, and expression, including freedom of the press and other media and communication, freedom of peacefully assembly, and freedom of association. Now, just an important note on the Canadian Charter of Human Rights. It applies between people in Canada and the government. It does not apply in between citizens. That is where our provincial charters of human rights come into play, which is where citizens can sue other citizens for breaches of those charters, as we saw in the Jeremy Gabriel versus Mike Ward decision. But as relates to the Canadian Charter of Human Rights, it guarantees rights on people in Canada from the government itself. And as we've now seen, Section 2 guarantees certain freedoms such as the freedom of expression. Section 1 provides that all of the rights and freedoms in the Charter may be subject to reasonable limits prescribed by law, as can be demonstrably justified in a free and democratic society. The decision itself was a split decision 4-3, illustrating that even at the highest court of the land there was substantial disagreement on the issue. Agree or disagree with the decision, the Supreme Court decided 4-3 that the Criminal Code did in fact violate Keegstra's rights to freedom of expression, but that this limitation was justified under Section 1 of the Charter. I do wonder what the outcome of this decision would be if it were tried today in today's current political climate. But this is the legal reality of Canada. Hate speech is not protected speech. Which brings us full circle back to the concept of hate speech and how it is defined in Canadian law. Hatred is predicated on destruction, and hatred against identifiable groups therefore thrives on insensitivity, bigotry, and destruction of both the target group and of the values of our society. Hatred in this sense is a most extreme emotion that belies reason. An emotion that, if exercised against members of an identifiable group, implies that those individuals are to be despised, scorned, denied respect, and made subject to ill treatment on the basis of group affiliation. That is the definition of hate speech under Canadian law. The question now is going to be what sort of regulation is going to authorize or require platforms from removing hate speech from their platforms? Is any such new regulation going to require platforms online to interpret speech on those platforms to determine if it fits the definition of hate speech in accordance with the Supreme Court of Canada? Is that even possible in the first place? Or is it going to lead to the reality reality where what is going to be forced to be removed from platforms is not necessarily hate speech as defined by the law, but rather any speech that someone doesn't like. We'll see where this goes. We'll see what the regulation is going to look like, how it is drafted. My only concern or query is that it seems we already have the laws and regulations and infrastructure in place. I'm not sure why additional regulation is required. I'm also a little concerned about this 24-hour window to comply with any such regulation. It is true that justice does require a speedy trial, but too speedy a trial itself can be an injustice. So that's that. Now you have a broader understanding of the overall context so that you can come to your own conclusions. Do you think this is a good thing? Do you think this is a bad thing? Do you think it's going to be put to good use? Do you think it's going to lead to even more problems? And incidentally, if you like my videos and content, please be sure to like, share, subscribe, hit the notification bell so you get notifications when I post stuff. If you want to support the channel, all support links are in the pinned comment below. And now you know your vlog. Peace out. Booyah!